We are live.
All right, here we go. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for October 21st of 2024. Brad, I got a mess here, so you go ahead and take it away.
Absolutely. We're a little late today because you're way out in Vegas or somewhere teaching, but this is good. Okay, let's start in New Jersey. We had a couple of short ones and then some long ones, but even
Mhm.
the short ones deserve a lot of good time and attention. So we're in New Jersey. They settled with a combat veteran who was not hired as a firefighter. It was a $415,000 settlement. So this was a Marine Corps vet. He's passed over by the Paterson Fire Department, I assume Paterson, New Jersey.
Mhm.
Allegedly, I guess, because this is a settlement, there's no factual determination, but allegedly due to concerns about his PTSD. So he sues for discrimination, and he was a combat veteran, is in Afghanistan, had PTSD, but he got cleared to duty. And we're not really, look, it's a settlement, right? As I say for all settlements, both sides think they had a possible chance of losing.
Mhm.
But this guy was, cleared. And not only that, he came out third on the Paterson Fire Department hiring list.
Yeah,
So I'm presuming what's that?
this is a tough it's a tough scenario. I've had to deal with this as an attorney. I've been co-counsel in a couple of cases like this. It's tough because these guys they come back and they're hurting. They're hurting. Some of them, get on a good trajectory, and there's a question about is this going to put them down in the dumpers again? And it's tough. And do they have the resilience? It's all about resilience. PTSD in many respects is about resilience, and you can only go to that well so many times. So
Right.
I have a great deal of compassion for the plaintiff here.
As
And
well as the
especially the
fire
fact that,
department.
yeah, but I have a great deal of, understanding too for the department and also for the psychiatrists or psychologists, trying to do the right thing for the member, even though he doesn't realize it.
Right.
Um, it's a lose-lose. It's a lose-lose.
It is. And look, disabilities, just very broadly for our listeners and viewers, if a disability prevents you from doing the job,
Mhm.
and you can't fulfill a job performance requirement, which is reasonably related to an essential function of the job,
Yeah.
then, you don't have to award someone the job. But here they'd be making an assumption without proof that the PTSD would be triggering, so, right, or triggered by some of the horrible things we see in the fire service. But without a psychiatrist saying,
Yeah.
you
And
know,
this, it can turn into a battle of the experts,
it is. So I think
and
both sides are right. I get it. We both get it.
I get it. It's really unfortunate, and it'd be nice if there was like a test. You put a bunch of electrodes like you do with a
Yeah.
rat, and you can sort of figure out where the harm is and whether or not it's gonna,
And the triggers.
impact them. But
Right.
it's really it's unfortunate, and you hope that the folks who were calling the shots here had the credentials and got it right. If they didn't, then that raises another issue, and
Well,
that's why we have courts, I guess.
but
That's
for those of you who are must-have policy subscribers, one of the policies and a very long video, I think I did at 45 minutes, was talking about job performance requirements and disability discrimination. And that's where you have to start. If you don't have job performance requirements and you don't understand how they relate to the job, and you're risking getting sued and losing in a disability discrimination case. And the mere fact that the video I did for that is 45 minutes to an hour just explaining the importance of job performance requirements should tell people how important job performance requirements are.
Brad doesn't like long videos
No, apparently not. Apparently
or
not.
policies.
So I know, true. So no, but so this, if you're a must-have policy subscriber, hey, you should be okay on this. If you're not, well, you're either not okay, or hopefully you're okay, or hey, join must-have policies. Okay, next. Um, Next, we're going to Texas. And I'm just starting with this before I get into the facts. I think the lawyer missed the boat. I think we should be talking about Family Medical Leave Act, if that would be
Yeah.
applicable here, and I assume it would.
Well,
So
as I was doing this, I was thinking about you and the FMLA. Yeah.
yeah, and we'll explain to the viewers why. But okay, so we're in Texas. We have a demoted and suspended fire chief who's suing now, alleging disability discrimination. And this is a little weird. I gotta say, there's something strange about this. He's proceeding under the Rehab Act, which personally I'm not totally sure applies, but and the Americans with Disabilities Act. Again, he's not proceeding under Family Medical Leave Act, strangely enough. And the FMLA would cover, and I'll get through what he's been doing, but would cover taking care of others with a known serious medical condition or taking care of yourself. And it imposes preservations for your job, even if it's intermittent. So even if your time off is intermittent. So with that
And
said,
it prohibits retaliation for taking that time.
yep. So to me, this is an FMLA case. I don't know what we're doing with the ADA necessarily. I mean, I get
I
it.
don't think a lot of attorneys out there think about the FMLA.
I agree.
Yeah.
And it's
So,
in this case, I think it's so much more applicable than ADA. But the ADA is equally applicable. In any event, here's what we got. We've got the chief who was demoted to an assistant chief. He alleges that, and then ultimately terminated. He alleges that he was being discriminated against on account of having diabetes, and we're going to talk about that. And he alleged that, well, the city considers him to have a disability related to the diabetes, which he does have a disability related, right? Diabetes is a disability. And because he's been attending to his father who has cancer. Now, I want to stop here. Forgetting the facts for a moment. The legal question is having diabetes prohibit you from being a chief? And that's going to be a complicated question. For example, it should, an NFPA 1582 lists type 1 diabetes as a class.
I hate to talk about my former employer, but the 1582, I know firefighters that have diabetes. They're insulin dependent diabetics, and they do a terrific job as firefighters. That's,
But the concern, which is valid, I'm not defending or not, but the concern which is valid is you're going to be working, pulling, sealing, doing search, and your blood sugar drops and you're done. That's a valid concern.
Well, that's, there's a lot of hypothesizing that can go along with some of this, but
same with seizures.
I think if somebody's got it under control, and some of my friends that they've got things with them,
pumps,
that in the event, well, they've got the pumps certainly, and they've got the monitors, okay, but they got a candy bar, or they've got different things with them, power bars, and the guy puts in a 30-year career in a metro fire department without an issue, not one issue. And then you say, well, hypothetically something could happen. So again, very specific, becomes a battle of the experts, where one doctor is going to say he can perform the essential functions of the position, and another doctor is going to say, oh no.
At least in this case, you've got 1582 as a standard to help you if you're on the defense side of saying, hey, diabetes is a class A, category A condition, which should prevent you, if you agree to that. Right?
Yeah. 1582 should not be, an absolute when someone can perform the essential functions. The ADA is really what governs. The NFPA can say whatever they want in 1582, but if you have the ability to perform the essential functions with or without an accommodation, the NFPA cannot override that.
And again, I think you had made the point years ago that these are entry physicals. These are not continuing physicals. So it might not apply anyway. He's already a chief. He's been with the department for years. So it may not be even relevant anymore. We don't know. This is just a complaint. These are just allegations. In any event, he claims he's being demoted from chief to assistant chief because he was giving priority, again, allegations, giving priority to his own medical condition and to his father's prostate cancer over his job. And that's where FMLA, that is the point of FMLA, to allow you to give your family and others in need of medical attention and yourself to give yourself that priority. So if this was true,
if the attorney is up on the FMLA, the only other reason why, and I still think you could get a retaliation claim out of it, if he had exhausted his FMLA. that would be the only, you know, reason why it wouldn't be in there. But even then, it still can be a retaliation for
Agreed.
having used it.
Exactly. That's the point. And having to separate whether he used it in the past or, well, he has no time
You
left.
might have to use it. Yeah, you might have to use it next year. And
yeah. Anyway, so it's an interesting suit. It's another disability discrimination suit. But again, at the beginning of this is if you're going to discriminate, and we're not saying that they did, the department did,
right,
but if you're
right.
going to discriminate, yeah, you better make sure you've got job performance requirements and they reasonably relate to the job. And I don't know whether chiefs have to be interior or not. But here's the interesting thing. What they're apparently saying is not that you have a disability and you can't do the job. It's that you're prioritizing your health over that of your job.
Yeah.
If that's
and
true,
they
that
essentially
sounds
told him that you need to. So
yeah.
Yeah.
Isn't that what we teach people? Take care of yourself first.
Mm.
No. Anyway, okay. Let's go to Palm Beach County. This is really interesting. So here's in short, a chief was terminated based on allegations that he harassed a female subordinate, which is incredibly important to this. And he claimed that the statute or the policy, which prohibited specifically sexting and texting, if it could be viewed as offensive, and that's the word he challenged, and he wasn't on horrible ground with that argument.
No.
Right, but he lost the lawsuit at the trial court level, at the district court level. He tried to say that the use of the word, I believe, offensive, right, and the whole policy was vague and overbroad, and he basically claimed that, and again, we know, and I'll let you kind of pick up why the word offensive sometimes is not specific enough as overbroad.
Right. Yeah, it is. I mean, it is one of those words, and it's kind of whether you get into conduct unbecoming or improper conduct. Those types of things can be problematic in terms of being vague under the 14th Amendment due process. It's, when we start looking at constitutional issues through the 14th Amendment, the employee needs to be on notice of what the requirements are. But here in the context of this, I think the court basically said it's pretty clear. It's kind of like what conduct unbecoming always comes up when I teach the discipline class. Yep. And I say, well, you know what, if somebody posts something inappropriate on Facebook and now you're going to discipline them as conduct unbecoming, that can be a little bit of a problem. Okay. If somebody commits murder, we're going to be able to fire them for conduct unbecoming. Don't worry about it. Okay. Right. So, but it's those close cases. And I think what the court was saying here was that given the gravity of what the chief did, and he wasn't denying that he did it. There wasn't a factual question about whether he did it. It was just that he felt that it shouldn't have, that the policy shouldn't have prohibited it.
Right. And here the court says, we're sorry, it wasn't that vague. A reasonable person should have understood what it meant. Right. And it really didn't authorize arbitrary, discrimination enforcement and discriminatory enforcement. It could be enforced consistently. In this sense, the term offensive is not vague.
Yeah, and I didn't put a lot of the details in there. For anybody who's interested, you can go, the decision is in there, and it's got a lot of the factual allegations. I didn't feel like, we need to rub salt in the wound there. Yeah. But I think when you look at the allegations, then you say, yeah, somebody who's a deputy chief or a district chief in a metro department really ought to recognize that this
should be sending sexual text messages to... Yeah.
But at the same time, I would expect an appeal here.
No question. Over the phrase offensive,
an appeal up to the circuit court. Yeah.
Yeah. I agree. I think you'll see that. But I don't want people here to feel that they should be using the word offensive in their policies. But the thing here, in my impression, that made it not vague is it was directly related to sexting. Right. Yeah. So if you had a general thing that said you can't ever say anything offensive online, that's getting thrown out. Right. But here, when it's so strictly tied with sexting and texting of a sexual nature, I think offensive has the obvious meaning in that context.
Yeah, and I think if we were dealing with firefighters at the same level, it would be one thing, but this was a chief officer, you know, and a firefighter that he was sexting. So
Yep.
I think based in context, just like I said before, if somebody's doing something close to the edge, maybe posting something inappropriate, conduct unbecoming or offensive could be a little bit, you know, close, and maybe you get a vague finding on it. You commit a homicide or do something really over the top, it's probably going to be upheld.
Yep. Okay, this next one is here's my lesson to attorneys. You really should be careful about what you say. And here's why I'm saying it. Let me give you the facts, but I think she loses on summary judgment right off the bat because of something she claimed. So here's what we have. We have a California Fire Protection District who's facing a lawsuit by a woman who's 55, and as long as you're over 40, you could sue for age discrimination in the US.
She's a kid.
Yeah, exactly. That's what I think. And she's suing also because of gender discrimination. She claims that she's one of very few females in the department, which is not per se gender discrimination. And she claims that she's one of the oldest. So she's one of the oldest and she's one of the only females. And so she goes through and she says, you know, the chief and deputy chief have been treating her with disdain and disrespect. And that led to the 2 disciplinary write-ups and led to her being placed on paid administrative leave. And the write-up said she's unable to act as a team member, but they didn't provide anything. So yes, that's not a great way to discipline somebody because on this date you did this or you didn't do that. And I was looking like, okay, maybe she's got a good case, maybe not. And then they say this. She claims, this is her allegation, which is, I think, the knife in the heart of this case. She claims that the disciplinary write-ups occurred shortly after she told the fire chief that if he, quote, continued to spend at his current rate, the fire department would be bankrupt and in the red by 2027. Okay, now wait a minute. That has nothing to do with age or female. And if I'm the chief, I'm coming out and I'm admitting that's exactly what pissed me off. I did not respect that comment. It challenged my intelligence. And based on that comment alone, I fired her or demoted her. I think she just ended her case with that line. She gave them an alternate positive reason for her action.
Yeah. Yeah. And, you know, one of the things that happens, and we don't think about this on the public sector side, but you have confidential employees, okay? In your law office, your secretaries, they're confidential employees. And I know, you know, when I worked for the NFPA, you know, your secretary, your admin, I mean, they're confident. And when you breach that, it's different than, you know, and certainly I'm sure a captain and the driver and the other firefighters, there's a level of trust and everything, but this is different when a confidential employee, especially high up in the front office, breaches that, steps over the line.
Yeah.
So I don't know. We'll see.
The McDonnell Douglas test, she is not going to fare well.
No. She'll get it over the net once, and then they're gonna hit it back, and that's.
I mean, I think it's not even a question of fact. She provided the reason they retaliated, and that has nothing to do with age or gender. So yeah. I don't know. I'm glad she's honest, but I think as a lawsuit, she just, you know, put the nail in the coffin. Okay, you got to do this next one. This is great, but Oregon, but you got to do this.
Oh my God. You know, you and I did this one. It was last year. I think it was last year.
Yeah,
but this is I'm going to butcher the name of the department here, but the Tillamook Fire Department. And they had a problem, and that was you can't make this stuff up problem. But there was some sort of an allegation that a firefighter urinated, and there was a female present, was outside, and all that. And bottom line is, they had it on video. Okay, so there's a video of it happening, and it wasn't that he wasn't on duty; it was, you know, an off-duty thing. So there was some other things about the sharing of that video, but the bottom line is that firefighter, possibly another one, I forget all the details, but that firefighter was terminated. Well, it turns out that he's also the mayor.
Yeah.
And the mayor didn't take it lying down, so now he sued. But one of his allegations, and you can go back and look at the earlier coverage, one of the allegations was that the sharing of the video or looking at the video, whatever, constituted, it violated the technical requirements of their revenge porn law. And I haven't looked at that statute in a while, so I'm not
Hard to
sure if that was
imagine it
correct or not.
does.
But bottom line is, now you get that they're all embroiled in this big battle now over that. There was discipline. There's a couple of people disciplined. Bottom line is the fire chief leaves. He departs. Okay, which you know, I mean, it's just a mess. Okay. Oh, by the way, the mayor then runs for the fire district board, and then gets elected to the fire district board. And I'm sure he was giving the chief the business as well. So now, bottom line is the chief leaves. Now they got a new chief. So the new chief comes in, and apparently a couple of captains were not happy with some of the things that the new chief was doing. And there's also some questions in the complaint about whether or not he was qualified or not. And maybe the two captains might have felt like they should have gotten the chief's position. I don't know all the details, but bottom line is, they apparently first went to the chief about some concerns about some of the things he was doing, and he blew them off. They went to an assistant chief who's, you know, obviously below the chief, and he said, take it to the board. They took it to the board, and then all of a sudden, you know, they started feeling the wrath of the new chief, to the point where they felt they had no alternative but to resign. So then they resigned, and now they're filing a lawsuit. So I don't know, you know, some places may have an excess of attorneys. Everybody's related to an attorney, right?
Yeah.
Most fire departments, when you have these kinds of squabbles, you work it out. These guys, they're working it out through the court system, which is good for our brother attorneys out there, brother and sister attorneys out there. But good Lord.
I know. And the end of this is they say that the chief's retaliatory measures were so severe that the plaintiffs were unable to perform their job duties, had no choice to resign. I don't know. That's a tough basis for a lawsuit.
You know, it's I don't know. I'm just, whenever you see this nest of, I've got now with this lawsuit, I've got either 9 or 10 lawsuits over a couple of year period, lawsuits and other proceedings, because there was some other proceedings, grievances and discipline and all that. But a total of either 9, because in the interim, there was another case that was filed in federal court. And it's not clear to me that it was related, but I can't believe that all this is going on and it's unrelated. It's just the timing is just, it's all in the middle there. So
it's a lot,
you know, like 10 different legal proceedings all in this one department over a short period of time. What is going on?
Yeah. And I got to tell you, when I see a case that's too hard to understand a summary of, it's a tough case to pursue, because people have to understand it, right? And if you're confusing your jury, they're just going to no cause you. They're just going to be like, forget it. We don't understand. You don't understand. And so when you can't even put it in writing in a succinct way that is easy to read, you know, and I think it's just very difficult to understand. I don't know. My advice to the attorneys prosecuting this is you better make it easier.
Yeah.
It's a lot of dots to connect.
Yeah.
No.
Again, certainly if anyone out there has more info on this that want to feed it to us, we're happy to, you know, I'll add it into my database and we'll keep it confidential. But this is like, what is going on? What's in the water out there? Why can't people work together to resolve these things?
Well, top-down leadership. If some of the commissioners, former mayor, whatever is a cause, then that can cause it. You know. Okay, well, that's all of it.
Yeah, that's it. I'm here. It's still sunny out. I opened the curtains here, but it's still sunny here in Las Vegas. So
get out there and go do something fun.
We will. I'm headed out tonight, so we'll have a good time. So,
All right.
all right. So, all right. Well, that's going to do it for another edition of Fire Law Roundup. We'll see everyone next week. And let's see, do we have something next week? I'm trying to think. We might actually be on time next week.
With any luck.
Could be. So, all right.